Yes, just before you start, Lord Goldsmith, I think in the course of argument I made some disobliging comments about the date of damage pleading, about the number of issues that were raised. I think perhaps I needn't have said those because one needs to have a fuller understanding of how you were going to put your case. So if anyone felt unfairly criticised, they shouldn't.
Oh, my Lord, thank you for that. My learned duty did feel some sensitivity about that.
Well, I was reflecting on it. I don't necessarily say that there's no room for criticism, but I hadn't considered it fully.
I mean, what he said was, of course, that this was an unusual case where the evidence and the pleading came together in a package.
I see that. Okay.
And my Lord, I'm on my feet just for one other point, and that was to try to answer, or in fact explain why I can't answer, Lord Justice Coulson's question about the transcript of the Court of Appeal hearing.
Ah.
And I think we have looked as best we can in the time, and I believe Dr. Blake's team have also looked. We can't find me saying on the transcript that we were not pursuing remediation relief in the 2020 action.
Okay, well...
obviously, we wouldn't need to do so if we had been allowed to pursue the 2017 action.
Yes, well, it may be that it was this is a case riddled with contingency positions or alternative positions, and it may be that was an unspoken contingency position. It makes no difference to that case, obviously, and I think ultimately it makes no difference to this.
No, it doesn't. But I just wanted you to know.
Yeah, fine.
Look,
yeah,
obviously,
I understand that.
We have pleaded it, and we will now be pursuing it to the extent that we are able to do so.
Yeah.
My Lord, I wasn't going to say anything about those 2 points. Actually, we haven't looked, I think, at the transcript, but I'm afraid because we saw that as a charge laid upon my learned friend, really to pick up on that. And I suppose, to be frank, I wasn't quite sure whether it really did have an impact on this appeal. So I wanted to concentrate on the issues there.
The general view of the bench is that although my Lord was clearly interested in having been in the other hearing, I think it doesn't actually arise, this appeal.
I'm obliged. So can I just say a very few words really about how we get here, though it's very apparent, if I may respectfully say so, that the court is fully aware of that, and on top of the plethora of judgments which have already been delivered and the procedural history. Date of damage, I want to just say a word though about that, because that is critically important, and my Lord's particular questions put my Lord Justice Coulson rightly identify that, and indeed my Lord Justice Underhill identify that as a critical question. It is something that Mr. Justice Stuart Smith, as his lordship then was, did believe needed to be done. My Lord Justice Underhill referred to paragraph 14 of his judgment where directions were given. I wanted just also to invite my Lords to paragraph 13, which spells it out a little bit more, preceding that. I'm sure my Lords have read it, but just to draw attention to it, I can now find the reference. Tab 37 of the supplemental bundle, page 331.
Oh, wait a minute. Sorry. I was looking at something different.
Well, there are a lot of judgments.
Well, yes, if it's the supplementary bundle, it's the order, not the judgment.
Oh, I see. Well, I understand that. It is in the supplemental bundle, but it's obviously also in the...
Oh, sorry, we have a separate judgment bundle,
no,
that's what I've been using.
And indeed, so do I. So I should have gone to that.
I'd rather look at that because this is some extracts. Yes, paragraph 13, yeah.
It's paragraph 13 of the 13th of February judgment, isn't it? No, not 13th of February. 27th of March, what we call the consequentials judgment.
Yes. Well, I have paragraph 13, and I obviously see why you attach importance to it.
Yes, I'm obliged. And while my lords have that open, we also play.
Well, sorry, just to spell it out, presumably it's the third sentence. Any pleading would have to be based upon evidence that justifies it,
Yep.
which in the present case would necessarily include lay evidence identifying when the claimants say they noticed or suffered damage.
Yes.
Was that your point?
That, yeah, absolutely, that is one point. And the second point is later in the paragraph that if the claimants serve their supporting evidence with the pleading, the defence will then know the case they have to meet and the evidence they have to either accept or dispute, and then they can be properly equipped to respond to that case with a view to trying the question when cause of action accrued reasonably soon, if that remains an appropriate cause. I'm going to come back to that. This is the prejudice point. My own friend insists, and he did it below as well, in saying, look, none of this matters because the only question is, did Bonga oil reach the shoreline? Now, that is a question, it's true, but that's not the only question, because the question is very much, and I'll come back to this, when it then, did it reach particular communities, inland, upstream, hundreds and hundreds of miles away from the coast? And that's the bit that is singularly missing from what was served in July. My own friend relies upon an expert report. He identifies it. This is one of the points I wanted to make at this stage. He said that it he described the report as showing, he said the expert shows that oil could migrate and might take years. He was right to use the conditional tense because it certainly does not show that it did. My Lord, I think Lord Justice Underhill said it's a report at a level of generality. It is, but it's more than that. It's a report at the level of possibility. At the level of possibility, I mean, we will deal with that. But the important proposition, and this does go to prejudice, as I've said, and I can take that quickly by asking my lords to...
Could I just ask one question while it's in my mind? It does. I'm not sure it's on exactly the point you're on, but it comes out of something you just said. You said that the issue is not just did Bonga oil come ashore at all, but did it come ashore at these distant locations, and if so, on what dates?
Or did it migrate to those locations?
Yes, very well.
Some of them aren't even on a waterway.
Very well,
yes. Maybe they are.
Fine. But I just wanted to clarify what it is envisaged the date of damage hearing would decide. It may be the answer is it hasn't yet been spelt out what it would decide because everyone was waiting to see the pleadings. But the impression that I have is that Mr. Justice Stuart Smith was only interested in deciding when did the oil on which the claimants based their case affect their particular communities, and that he would treat it as a separate question, which would have to be decided if the claimants got over the first hurdle, whether that was Bonga oil. You following me?
Well, I am, though it's not how I understood it. And if one looks, perhaps if we just look at one of the witness statements which was served, which we've got in the supplemental bundle, just to see how the other side have approached it. So we've got...
Yes, well, if this is your only point, perhaps we needn't go to it. I think each of them, but certainly one or two of them, say not only oil came ashore on such and such a date in 2015, but also, and it seemed to me obvious it was Bonga oil because they give some reasons. Is
Well,
was
they
that
don't
your
give
point?
reasons.
Or-
Actually, they don't give reasons, and that's what I do want to show, my lord.
yes. Okay. Where are we going
If
now?
we look at tab 20 of the supplemental bundle, which is Mr. Demayin, page 1, starts at page 123 of the bundle, and I want to go to paragraph 6. Where he says that oil from the Bonga spill first reached my community on the 1st of June 2014. I witnessed the oil myself. There was a huge slick of oil along the coastline. Then the next sentence, I knew it to be Bonga oil spill because it was the only oil spill at the time. That's it. That's his evidence. If one goes to the next witness statement, at tab 21, which is Mr. Kingsley Afuna, paragraph 6, he says the same thing. I witnessed the oil, it was all over the place. I believe it was from the Bonga oil spill because it was the only spill at the time. And I think I'm right. But the other witness then is Mr. or Miss Kimball.
He says the same.
Exactly the same. It's a sort of pro forma witness statement, frankly. And Mr. Emmanuel. Now, he, in paragraph 6, he gives rather more, graphic evidence about the presence of crude oil and why he couldn't forget the date. But I'm not sure he says why he believes it was Bonga oil.
No, I don't think he does. But just to focus on this for a moment.
Yeah.
Given the context in which the preliminary issue came to be directed, it would make sense, wouldn't it, for the only issue to be determined to be on what date did the oil of which you complain affect your community? Because if the answer to that was a date after the limitation period had come down, and there were various different limitation periods in issue at the time that Mr. Justice Stuart Smith first made his order, that would be a self-contained and fairly narrow point. It might not be that narrow if you had to decide it separately for all of 400 communities, but the issue would be quite narrow.
It wouldn't be a very helpful point.
Well, it would, wouldn't it? Because it would be helpful to you if the date was after what he found the limitation period, but limitation bar to have approved.
Well, that's true, but it wouldn't be helpful for an issue to be tried over 4 weeks to determine that somebody suffered some damage from some. There's oil all over the Niger Delta, and I want to come to that. Just to say there was oil on my land at a date in this period doesn't actually advance the claim, which is what Mr. Justice Stuart Smith was concerned about. Do they actually have a claim which is not statute barred? And they do, of course, need to demonstrate not just that they saw oil, but it affected their land or their fisheries. Or
no, of course, that's crucial for liability, but for limitation, it's only, there will be a rational case for saying the preliminary issue is only about your complaining that Bonga oil hit your land on the date that that oil occurred. Was it after the limit, where that damage occurred? Whether or not it was Bonga oil, had the limitation period passed?
Well,
but the truth is this right, that nobody has really focused on the question of what the scope of this issue will be, because Mr. Justice Stuart Smith thought, well, we better get it all pleaded first, and then we'll be able to see.
Well, I'm not sure that's fair, my lord, because
no, you tell me.
We've certainly through.
No, in a moment, Mr. Dunning.
There is another order on this, my lord.
Well, Lord Goldsmith will tell me. What were you about to say, Lord Goldsmith?
What I'm about to say was we certainly, and this is why we have been talking about prejudice particularly, because we need to investigate, just in a short sentence, we need to investigate where and when it is said Bonga oil arrived. And the learned judge picks up on the need to investigate. We're not trying to investigate whether there might have been some oil, because as I say, we know it's all over the Niger Delta in different places. We needed to investigate, is there a credible case that
Yes, I see.
Bonga oil that affected this? We know there's an arguable case that Bonga oil reached the shoreline, and people say that they saw it a few days after we know there was a spill from the Bonga, from the ship, or not from the ship, from the storage tank. We know that, but we found it incredible that it is suggested that people were affected by Bonga oil years later, hundreds of miles, and perhaps even thousands of miles, inland and some upstream. And that's why we've said that critically, that needs to be determined as a threshold issue.
Yes, I see. Okay, well, my first impression may well be wrong, but that's exactly why I wanted to identify what, on your understanding, the issues at this preliminary hearing would be.
Yes. Well, that's.
And you're saying it includes not only when did the oil of which you complain come ashore, but was it Bonga oil? Okay, well that's very helpful.
And I think. Sorry, Michael.
You go next.
I was going to say that in the judgment which was delivered yesterday.
No, representative judgment.
Oh, this is Mr. Justice Stuart Smith's. Sorry. If we go to the representative judgment, that's bundle E, tab 3.
I haven't looked at that for this purpose. Yes.
I actually do think this is reflected in the representative's judgment from this court, which was delivered yesterday as well, because that's what was reference to individual cases. And it's not, I didn't understand it to be just, whether there was some oil. But that's at tab 3, and at page 144.
Yes.
At paragraph 72, my lords can see this is Mr. Justice Stuart Smith, as his lordship then was, discussing the need for consideration of individualised claims. My lords would kindly read that, and I'll pick up then on the passage.
Well, the whole of 72.
Yes, please. It's talking about the pollution caused by the Bonga spill.
Yes.
And I'm going to come to the evidence of Miss Kebiatemi in a moment, which I've cited, I think, to every court that's considered this so far. Lord Justice Coulson may have to look at it for maybe the third time. And of course, the evidence that my learned friend has made such play of having served about how his experts demonstrate that Bonga oil could have reached positions inland is irrelevant unless that is an issue that we need to consider, not just whether they're affected by oil, whether they're affected by oil.
No, I see that.
My lord.
Has the preliminary issue, which is going to be tried next February, ever been identified?
I think, my lord, it's been identified. Whether it's been formulated precisely, maybe a different question.
Well, perhaps this is the point to allow Mr. Dunning, who's busting keen, to tell us there's another order. Mr. Dunning, what's this other order you want to refer us to?
Well, this was the order. Sorry, this was the order made in November, which is dated the December. So it's the first order of Mrs. Justice O'Farrell, which is at tab 18 in the supplemental bundle.
Give us a moment to find it.
At page 115, tab 18. Now,
yes,
it's paragraph 7. Now, it may be said that still leaves some scope for debate, but I did want you to see that there has been a more precise order, which wasn't part of Mr. Justice Stuart Smith's order.
115.
Yes, paragraph 7.
The date on which the claimants first suffered actionable damage,
Yeah, and
i.e. Bonga oil. They wouldn't have suffered actionable damage if it wasn't Bonga oil.
exactly. And it's a trial, so it's a trial of the date on which they're not simply looking at the date and saying, is that in time or not? And
let's
then other
just
points.
remind ourselves of what the order, what Mr. Justice Stuart Smith's order said. Which is behind tab 13, is it
Tab
not?
13.
Or is it? I think we're on one. Yes, that's right.
Yes.
This is a strikeout application. Is the strikeout application the same as the...
No, it's not really the strikeout. It's the it's what we call the representative.
Yes, quite.
But
What I'm trying to find is whether, and if so where, Mr. Justice Stuart Smith made an order for a date of damage preliminary
yes,
hearing.
it goes back to the jurisdiction judgment.
Yeah. Well, okay. Yes.
So I think if I take my lords through it, the proceedings were issued as has been said, including by my Lord Justice Coulson in one of the earlier two judgments of this court. The proceedings were issued hard up against the perceived expiry of the limitation.
Yeah, you know that.
And in fact, it was later than that because of the late addition, because of the dropping out of the anchor defendant they'd started with, because they recognised.
Yes,
that
and they had to introduce a new
it's a
one.
later
Yep.
date.
Yep.
My lords have got that absolutely. And then when he came to deal with jurisdiction, I mean he was of the view that almost certainly the claims of coastal individuals, which is all he thought he had in front of him,
Yes, right.
were certainly time barred.
Yeah.
Ergo, there was not a case
Right.
to be determined, and so there shouldn't be leave to bring the foreign defendant in. My lords have got all of that. But he left open the possibility that some individuals might have suffered actionable damage at a much later point in time.
Yeah.
So one needs to look at this for the March judgment.
Yeah.
That was 59 to 16 274. So if we just look at that.
Well, it's exactly what I have been looking at over lunch.
Yes.
59 to 60?
59 to...
You mean, sorry, are we, this is the judgment of the 27th of March.
But we look at the judgment. Yes, the judgment, not the order.
No, quite.
So 59 to 60. Trying to turn out my own bundle.
Well, sorry, can we not, if we look at, well, I'm using different references, I'm looking at a different bundle. If you look at paragraph 16 of that judgment,
Yes.
One, he sets out the directions of which we're concerned. Two, he sets out the directions relating to your client's response to that. Then at 3, he says there'll be a CMC.
I don't say paragraph 16. I'm sorry.
I think you may be at cross purposes. I think my lord is in tab 2, the consequentials judgment
Yes.
of March.
That's not the judgment I'm asking my lord to look at. I'm
No,
asking my
whereas
lord.
I think you, Lord Goldsmith, were referring to paragraphs 59 and 60 of the original judgment. So tab 1.
Tab 1. That's right.
Which is the bit where,
Yes, I see.
where
apologise for
Lord
not
Justice
making
Stuart Smith says the damage would have occurred within a few days.
Yes.
Yes, but all this is, I'm sorry, if these are important points you want to make for your own right, Lord Smith, I'll shut up. But in answer to my point is a much narrower point. I just wanted to find out whether there was any order, as opposed to passage in a judgment, specifying what the from Mr. Justice Stuart Smith specifying what the preliminary issue was.
Yes, the answer is it's behind tab 13 in the supplemental bundle.
Yes.
14.3. There'll be a CMC. The present target is to have a preliminary trial if appropriate, or preliminary issues A, the date, B, the appropriate limitation periods. And
Well, I'm
the
sorry,
limitations
where
to defence.
so
So that's page 79 of the supplemental bundle behind tab 13.
Yes.
And then that was effectively translated the following November by Mrs. Justice
Yes.
O'Farrell in that order that Mr. Dunning showed us.
yes, but
So that's the start of it. And I don't think there was anything more. I don't think there's anything more specific than that, is there?
no. Well, maybe there isn't. Thank you. And that is exactly what I was looking for. There is a sort of ambiguity there, isn't there? You've explained very clearly why you think the judge must have meant not just the oil of which, when did the oil on which you complain wash up, but whether that was in fact Bondra oil. If that is decided, then really, it's in a sense, it's not really a preliminary issue, because it decides the question of liability, doesn't it?
Well, it may or may not. What the judge was concerned about, which was why I was going to the jurisdiction judgment, the first judgment, is because that's the outstanding issue which will determine whether or not there is an arguable case, and therefore whether or not it should be permissible to serve these proceedings out of the jurisdiction. That's the feature. And that's, I mean, one has to read the March judgment, which I was doing, to get to that point. Therefore, that issue needs to be determined. And that's the way that the learned judge got to it. Having given the jurisdiction judgment, he then said, well, that's what we now need to do, because that's the one remaining piece of the puzzle as to whether or not there is jurisdiction. And so that's what he ordered to be tried.
Well, what concerns me is that if this is all basically simply preliminary to whether there's jurisdiction in the first place, isn't that what you were just saying?
That's how it emerged, yes, indeed.
Then the purpose of it will be perfectly legit. On the whole, in a jurisdiction context, you don't ask were they liable, but is there a reasonable case that they were liable?
Well, what we have is the order that the learned judge made that there should be a trial, though the precise contours of the trial will need to be determined once the pleadings have been...
No, I see that. But conceptually, this is a trial still going to the question of jurisdiction?
Well, it is. It is going to the question of jurisdiction, though, of course, as often trials on jurisdiction do, it will also answer questions, or may answer questions, which go to liability as a whole.
Well, if the judge said, there's three possibilities at this preliminary hearing. I'm sorry to take so long about this, but it's important to feel firm ground under my feet. If at the preliminary, the judge says, that the case is hopeless, that will be a reason for not acknowledging jurisdiction, and formally the order, I think, will be that to refuse jurisdiction. If the judge says that the case is arguable, then jurisdiction will be accepted. Why will it ever be relevant, if it's all under the wrapping of jurisdiction, for the judge to say, and it's not arguable, but actually it's obviously right. I've heard the evidence and I'm satisfied on the balance of probabilities that... I may be being... I'm trying to understand what this hearing is for.
Well, that's what I was trying to take my lords to.
All right, I'll shut up and let you
No, please don't shut up, because it's very important to understand. I'm sorry. Please don't stop. Please don't refrain from asking my lords questions, is the way I should put it. Because it's important to understand what's troubling the court. I did just want to make this point. We haven't got an appeal or even a discussion of the orders that were made. That's not the issue. The issue before your lordships is whether there's a reason to interfere with the discretionary judgment which is Justice O'Farrell made. I know my lords understand that, but I think one that does need to come back to that each time, because it may be that Mr. Justice Stuart Smith could have found a different way of proceeding to where we're going, but he didn't. And there's been no appeal against that. That's not what my lords are considering. What he has done, in my respectful submission, is made it clear that what needs to be served, and that's what we're talking about, is a date of damage pleading, which doesn't just say, I saw some oil on my land at this date, but a contention that it was bonga oil. Then we know where we are. And I'll come to what Miss Atemi says and what we would need to do. And as my Lord Justice Coulson picks up, it's about actionable damage, and it wouldn't be actionable damage unless it was bonga oil.
So what issues on liability will remain to be determined if the claimants establish that it was bonga oil and that the date was after, it was within the limitation?
And lots of issues. For example, was the actionable negligence which resulted in that oil reaching that particular place, whether or not there is a claim by that particular claimant in respect of it, and that my Lord Justice Edis raised a question about, or touched on a question about whether or not what the proprietary interest of a particular claimant may be.
Yes.
All of
Remedy is another thing.
and remedies would be a very big thing.
Yeah.
So it would be a substantive. Well, actually, my learned friend Dr. Blake has rightly reminded me that remains open an issue, which my Lord Justice Coulson may recall, we almost raised by way of respondent's notice in the first of the appeals which reached this court, about whether or not there can be a cause of action in nuisance when the spill took place at sea. Not inviting
Yes, I rather assumed, I hadn't bothered with this, but I'd rather assume the primary cause of action was in nuisance.
Well, they're
You're
alleged.
talking about negligence.
Well, they allege both.
Yes.
But my Lord is, I mean, it's right. Then there is a question about whether or not, we say whether or not you can have nuisance in relation to things which happened at sea. Not.
But that interesting question would be decided only, you say, if you're wrong and the court concludes that it does have jurisdiction, because
Yes.
the claims aren't statute barred.
Yes, yes.
First instance jurisdiction was
I mean, it's quite a convoluted, or at least a lengthy procedural history, because the thrust of the action was negligence, so it seemed, but nuisance is alleged as well, and that gives rise to an important question, because, of course, the liability will turn on different factors, whether it's negligence or whether it's nuisance.
Yes, indeed. And it's now coming back to me. I think there's a Rylance and Fletcher claim as
There's a
well.
Rylance and Fletcher claim as well, and can that arise in circumstances where it's at sea? All of this would be for a later date, but the starting point is, as I showed my lords, Mr. Justice Stuart Smith, because of the way the case had been run before him, up to that point, right until September 2019, believed that there was a monolithic claim being put forward. Oil left the vessel, arrived on the shore within a few days, and polluted the coastal area. And his view was, and it's difficult to disagree with this, that if that's what happened, then it is likely that the claims of all those people on the coastal claim would have been statute barred very shortly thereafter.
Against Tasco.
Well, against Tasco, because that's what matters for limitation.
Yeah, quite.
As it happens, it may be against the others too, but that doesn't matter for jurisdiction point, as my lord's right. And that's why he said, and I think I got to that paragraph, he said that that's why limitation mattered. This is paragraph 59 of the judgment of tab 1, my lords, either. And I do thank my Lord Justice Coulson for having picked up. We were looking at different judgments. In the middle, the sentence starting, however, it's clear beyond reasonable argument to the contrary that actionable damages alleged would have been suffered along most, if not all, of the affected shoreline within weeks rather than months of the December 2011 spill. I underline the word actionable, which we then see as my Lord Justice Coulson picked up in the order itself. Not only is there actual evidence of oil reaching the shoreline about the end of December 2011, but also no plausible mechanism has been suggested that would lead to the December 2011 spill getting as close as it did to the shoreline by 24th December 2011, but then, assuming it did, causing such havoc over the allegedly affected shoreline only after some extended delay. Doesn't mean that all claimants living and working on the shoreline were affected as soon as oil first hit land, but the substantial quantities of polluting oil alleged by the claimants strongly support the conclusion that where oil hit a particular stretch of the shoreline, many, if not all, claimants living and working in that area would have suffered one or more of the effects of which they now complain within a short time. Even without conducting a mini-trial, therefore, the court can be confident that actionable damage sufficient to start time running in negligence and or nuisance occurred for many claimants before 4th April 2012. My lords will recollect that 4th April 2012 is the critical date because that relates to the addition of Stasco. And then he makes further references. Then he says
all of that is now established by the expert's report served by the claimants, because the extracts in the date of damage pleading make plain that the oil struck the coast. I think it's the 24th of December, and there are maps which show the oil on the coast. And there's a lengthy section that's in the date of damage pleading. But of course, all of that, very interesting by way of background, but as as Mr. Justice Stuart Smith had shown, that of course is all statute barred on any event.
Exactly. So that demonstrates that statute barred. And this is then in September 2019 and October 2019, my learned friend says first orally on his feet, oh well, some of them may have suffered damage later. Never been said before, not pleaded. That's what then led to this. And so in paragraph 60, if my lords would very kindly read that, his lordship then notes that there's no material before the court, that we don't have a reasonably arguable case on limitation for the action as a whole, for the reason that he gives. Then notes the claimants don't plead when they first suffered damage, either in general terms or specifically. Neither in the pleadings nor in evidence is there any analysis of the location, alleged date of damage, or mechanism of migration, heads of damage caused by migrating oil. The only assumption that can safely be made is that further from the shoreline, the more remote in time it may ultimately be alleged the damage was first suffered, the greater will be the need for the case to be properly pleaded and for evidence both general and specific to sustain a claim that the individual claimant suffered actionable damage by Bonga oil. Not suffered damage from some other oil, but it was by Bonga oil. So the conclusion then is, in these circumstances, apart from being confident that any claimants who have not suffered damage by 4th of April 2012, but who will ultimately prove they have suffered damage thereafter, will have suffered damage progressively, depending upon their distance from the coast and the existence of pathways for pollutants to follow, it's not possible to determine which claimant suffered actual damage when. And so his conclusion at 61, clear that many claimants will have suffered actionable damage before April 2012. On present information, the defence of a reasonably arguable case. On limitation, possibility some suffered damage between 2012 and April 2012 and June 2013. But on present information, it's not possible to exclude the possibility that some claimants may first have suffered actionable damage after June or even October, November 2013. Present no reason to conclude that they did, and not possible on present information to reach any further conclusions. Now, what then happened, and I think I'll be told if there's an intermediate step, is that then led to a further hearing to consider what the consequences of that judgment were. And that's what then led to the second judgment in March, what we call the consequentials judgment, which is at tab 2. And in paragraph 4, to read this, the main judgment, that's the one we've just been looking at, sets out the history of delays on the part of the claimants, both before and since issuing proceedings. Just to interpolate, it was noted in this court that it has never been explained why they waited until the date that they did to start proceedings days before they themselves thought limitation was going to expire. And indeed, it may have expired a year before because of the issue about what Nigerian law provides. What matters most in my judgment, for present purposes, it appeared until the morning of the September 2019 hearing that the claimants were taking a unified and unitary approach to limitation. There was nothing in the pleadings to suggest there were multiple different dates spread over many months or years of upon which individual cause of actions accrued. Some such indicators there were suggested the opposite. Paragraph 5 of the particular claim alleged that the claimants are Nigerian individuals and communities occupying land along the Nigerian coast on the Atlantic Ocean spanning Bayelsa and Delta State. It appears from a map produced for the present hearing the address given by the two lead claimants was on the coast. The particulars of loss suffered gave no indication of any significant time lag. The evidence put forward by both sides for the various applications strongly suggested that if the Bonga oil reached land, it did so soon after the spill. Even as late as their written submissions for the September hearing, the claimants accepted that the defendant's position on limitation was arguable without qualification. On the basis that it was appropriate to adopt a unitary approach to limitation, this concession would be sufficient for the defendant's purposes on the applications and meant there was no divergence of interest between claimants on limitation. The claimant's response was to try to put in evidence about the date that damage was suffered many kilometres from the coast after the October hearing, and that evidence was ruled inadmissible. That's part of the procedural history. But my lords can see, I don't need to read that, that then what happens is then that if we go to paragraph 13, which we looked at before, that's why we now get to, well, what are the further case management directions that should be made? And it had emerged that there was common ground that there should be a date of damage pleading. And his lordship ordered that it shouldn't just be an assertion, but it should be based upon evidence that justifies it. That's lay evidence and also any expert evidence. And if the claimants serve that, the defendants will know the case they have to meet and evidence they have to either accept or dispute. They should then be properly equipped to respond to that case with a view to trying the question when causes of action accrued reasonably soon, if that remains an appropriate cause. So it was going to determine the question when the causes of action accrued. And it was all under the umbrella of jurisdiction. But I think I'm right that we may, or have we issued a reverse judgment, summary judgment? No. Well, I wonder whether we'd issued a reverse summary judgment application. It may be that we will, if we haven't done so. I don't know. But I'm told we haven't. But that doesn't matter. But in any event, his lordship had focused in on the date of damage in this way. Now, if we deal with the evidence point, my lord's, of course, right, my learned friend is right. He wasn't ordered to provide a witness statement from every claimant. That's true, but it is important as to what the learned judge decided, paragraph 14, as my lord picked up. Well, some of them may actually be, it may be, it's the same date for many of them, for a number of them. Well, that's a common sense, sensible point. Some of them live in the same village, the same community. It may be they all suffered damage, if any did, at the same time. And therefore, his lordship made it clear it's not a requirement of this order. Evidence from each and every claimant must be submitted. It's not prohibited. It doesn't have to be submitted. And also doesn't prescribe any particular form of date of damage. Interestingly, he invited the defendants to refer back to the court for further guidance. The only guidance that the claimants have ever sought is to come back and say, can the time that I've been given be changed? Never come back to explain, even now. And fundamentally, at the end of that paragraph, something which is picked up by Mr. Justice O'Farrell, the defendants must know the case they have to meet with sufficient particularity to enable them to respond and defend their interests fully and properly. Because it's open, I also want my lords to note two other points on this page. Firstly, what his lordship said about there being no more iterative approach to this litigation. In fact, despite that hope, that's exactly what's happened. It's exactly what we're seeing, time and time again. The claimant should assume they have only one opportunity to get their case in order from now. And then the claimants raised the difficulties caused by the current pandemic, which I think had just started at this date. His lordship takes that into account and extends the time he would otherwise give by 2 months to allow for possible difficulties caused by the pandemic, and sets out then there's the 3 elements that need to be provided. on when all relevant accruals of damage occurred with sufficient particularity to enable the defence to know the case they have to meet, any lay evidence upon which they rely in support of that case, and any expert evidence on which they rely. But it's focused on not just when did oil hit their land, but on when there was relevant accrual of damage. Not determining whether there should be remediation, not determining what the quantum of damages should be, not determining actually what the extent of the damage was, but that's what was required. That's the order we've been working to over a period of time, and the courts have been working to. Now, my Lord, I promised, or threatened might be how your Lordship see it, that I would come back to Miss Atemi's evidence as to why the details matter. I keep on making the point, there's oil all over the Niger Delta. Can I just take my Lords briefly to her evidence? My own friend fairly noted that he referred to it, he recognised its existence. But her evidence is to be found in the supplemental bundle, extracts from it at tab 15. I'm not sure my Lords can see from this actually who she is. She was at the time, she was the legal manager for all Nigeria, I mean, for the Shell interests in Nigeria. She now has I think, even a higher role, but very experienced. And in paragraphs 9 and onwards, she describes the overview of security and pollution issues affecting the Niger Delta region. And she suggests that it's necessary to look at that. I wonder if my Lords might be willing to read at least paragraphs 9 to 13 just to themselves, and I'll come to paragraph 14.
Give us a moment. Yes.
So I invite my Lords to read out paragraph 13. That's the sort of generality of the problem. Then paragraph 14, she starts to talk about the actual causes, the actual contributing factors. So from paragraph 14, she talks about what's called, well, oil theft and illegal bunkering. Now, bunkering here does not mean the method of filling ships with fuel that they want. It's actually an illegal activity of abstracting oil from pipelines and then refining it in crude, homemade refineries and using it. And as paragraph 15 notes, crude oil theft is the single most critical challenge facing the oil industry in Nigeria, and then refers to certain publications. It's Nigeria's, some people say, most profitable illegal private business. And there's talk about the extent of the revenue. Paragraph 16 notes the documentation of the extent of crude oil being stolen in Nigeria. And paragraph 17 picks up on the different ways this is done, which includes, as my Lords can see, just from the sort of subheadings, some of it is small-scale pilfering and illegal local refinery. Some of it is large-scale illegal bunkering in a field. So it's industrial theft and industrial refining, but on an amateur basis. And paragraph 18 explains, and this is important, what happens, what a term artisanal refineries, which I've always thought is a rather charming expression for what is in fact simply an illegal activity. They cook the crude into separate petroleum products. The point is they can't refine it all. And so, as my lords see, the remaining 55% of crude goes to waste, most of which is dumped. They can take about half of it and use and then sell it afterwards. The rest of it they just dump into a shallow pit or into the waterways. And those, we assert, paragraph 19, are the main sources of pollution in the Niger Delta. Now, having done this, she then, having talked about the generality of the problem in the Niger Delta, she then talks about particular areas that we're concerned with where the claimants or would-be claimants have their residences or their farms or whatever, their fisheries. And my lords can see the extent of it. Like the final sentence of paragraph 19, every day oil companies in Nigeria lose between 300,000 and 400,000 barrels of oil to illegal theft. It accounts for 15% of Nigeria's 2.4 million barrels a day. The efforts to combat it, paragraph 20, are ongoing. See the extent of it, 2,000 suspects in 2012, 4,000 refineries, 30,000 drums of stolen crude products were destroyed. And of course, this has a huge effect on the environment. She then goes to talk a little bit about SPDC, and I don't need SNEPCO and SPDC, I don't need to spend time on that. But paragraph 24 gives some of the statistics in relation to these causes of pollution. So, final sentence before the subparagraphs. Total oil spill worldwide in Nigeria between January 2013 and December 2016 was just over 11,000 oil spills. The total number of spills across all 9 Niger Delta states totaled 9,343. And if we just look at the Delta and Bayelsa states, which is where these claimants are from, the total oil spills occurring was 4,415. And of course, there may be some spills which are operational, caused from pipelines which are leaking or something like that. But the statistics coming from the official organisation, the National Oil Spill Detection and Response Agency, is nearly 3,000 were caused by theft or sabotage. Now, this all accords, she goes on in 25, with the evidence, with the experience that the company itself has.
So this all goes to what?
This all goes to why we... Sorry, my lord.
So for the purposes of this appeal, I mean, obviously I've read this before.
I know that.
But where does this, what does this go to?
This goes to what we need to have the dates and places of alleged oil pollution which the claimants are relying on, because we will want to investigate that. The judge recognised...
Investigate in what sense?
Well, in the sense of, there are a number of things we can investigate, but for example, if it said that oil spilled on this land at this place at this time, we will want to investigate whether there were spills recorded already that we know about, which are a more probable cause of that than that it's from Bonga oil which has spread somehow hundreds of miles. And the learned judge recognised that was something that, and indeed Mr. Justice Stuart Smith, that we should be entitled to investigate.
In this witness statement, we show that some of the communities, contemporaries of oil spills we can from other sources.
Yeah, just point.
It's in 41.
So, well, I'm obliged to Dr. Blake. What he's reminded because I know it, but it's, if my lords read the rest of what Miss Atemi says, she identifies at paragraph 41, for example, what actual other spills there were at that time in these places. In paragraph 41.2, she identifies another oil spill ravaging the communities of Baturin, Degale and Benekruku. Baturin is one of the places that's particularly said to have been affected. Claimants from there are alleging this is Bonga oil. I mean, the assertion that, my lords can see, the assertion that there were no other spills at the time in these witness statements is absurd. And then paragraph 41.3, if we go to 24th of November and 5th of December 2014, spills from the Transforsados pipeline at Batan, at Warri South. And 41.4, Warri North. That's one of the places which is an issue here. So of course we need to know. We regard it, and our clients regard it, as implausible, to say the least, that oil could have migrated the distance and over the time that is said, and in the circumstances that is said, some of which is allegedly upstream. And it's much more likely that if these people did suffer oil pollution, it was not coming from Bonga oil. And that's what we're entitled to investigate. And it takes time. Now we've got evidence, as this shows, we do know about some other spills that took place. And in her judgment, I suppose particularly at paragraph 43, it's going to make one sort of preliminary, just very short submission in relation to this judgment. It was, of course, extempore, and if I may respectfully say so, a very good judgment despite that. But we'll all knows that the result of that is it may not be as completely crafted in the way that if she'd taken time to do it, it would have been. But none the worse for that. But in any event, at paragraph 43, I made this submission to her. I said, this is why we need to know, and she accepted that. That's what she's saying in paragraph 43. That we're entitled to know with precision the case that we have to meet. Regardless of their primary defence, now she's obviously taking from Mr. Dunning what he said our primary defence was, what he actually would like to say it's our only defence. I'm sorry, it's not for him to tell the court what our defence is. He wants to say our only defence is that it never reached the shoreline. That's true, that's what the clients believe, that it didn't, and they believe they'd cleaned it up. But there's still a very substantial question. Even if it did, is it really conceivable that what happened was that this oil went the distance that it did, in the way that it did, over the time that it did? And we're entitled to investigate that, to present our own case, which we might do by factual evidence, or by expert evidence, or simply by doubting the evidence that is put forward that it was Bonga oil. She said we're entitled to have an opportunity to consider the detail of the case and the evidence put forward in support, so we consider whether or not to challenge it. We're also entitled to a reasonable opportunity to prepare our own case. And she comes back to that at paragraph 45. When she talks about the need for us to have, be able to investigate this formidable new case. My Lord Justice Underhill was quite right to describe this. It was a new case. This was originally presented as a monolithic case. And if one looks at the claim form, my Lords will see that the claimants are all described as on the coastline. That's what we thought. That's what Mr. Justice Stuart Smith thought he was dealing with. It wasn't until Mr. Dunning said orally at the hearing, oh, well, maybe. He didn't say they had. He said maybe some of them suffered damage later. September 2019, that's recorded by the learned judge. Now, Mr. Dunning, I don't know, perhaps he failed to understand this. I find that very hard to believe, but never mind, that's not the point. When it comes to the time that we need, he says we don't need any more time. Well, that's just absurd. We were given time for a very good reason, and we need it in order to investigate and present our own case. And that was the debate before the learned judge. She made a conclusion about it, and I would respectfully submit that it's not for this court to interfere with that evaluative judgment she made, that we would suffer prejudice, and that there would be, as a result, the trial date set for, it'd been proposed for a year, I think it'd been set for 10 months, but in any event, a 4-week trial, February next year, coming shortly, that would have to be vacated with all the consequences. When one looks at the factors in place, and I will come back to this, my Lord Justice Coulson has very rightly, from his says, picked up on Denton and White. But amongst those factors to be considered, if my lords were considering exercising a discretion afresh, would be the claimants have had 16 months to put forward their damage claim, and they want us to have only 3 months, even though the orders originally provided for more. I'll come in a few moments to talk about whether the claimants actually have demonstrated that they did do, as Mr. Dunning persistently says, all they could have done, which we frankly do not accept for a moment. We find what they say they've done incomprehensible.
I think the primary case now is you can only have 2 months.
Only have
they
2
say
months.
that you've got to, if they're entitled to provide this new information by tomorrow,
Yes.
then but your date stays the same.
My date stays.
So that would be 2 months.
And therefore the trial, and he says, and the trial, no reason why the trial shouldn't stay the same.
Yeah. I mean, Mr. Dunning accepted that if there was a shunt, if the period was maintained, then the February trial couldn't be maintained.
Yes.
But, so Mr. Dunning's submission is they don't need more than whatever it is, 24th of November, whatever the date is where you have to respond.
And my lords, yeah, I'm very much obliged, that's absolutely right. I'm sorry, we don't believe this case. We don't find it difficult to believe that certain claimants may have been affected by all because there's a lot of it in the region. We don't accept. And there may be a case about the shoreline, of course, because that, at least to say I was affected by oil within days or weeks of what we know was an actual spill is one thing. But to say more, we don't accept it, and something else is going on, and so it's right that they should have to say what their case is, and we should be able to test it properly. So I've sort of dealt with why we say there's nothing wrong with the learned judge taking that issue into account in the way that she did. And I'll move on to certain of the other points. My learned friend says that this highly experienced judge, head of the Technology and Construction Court, didn't realise what the effect of her order would be, although he himself says, I told her over an extended period. This hearing took a day, a whole day, and Mr. Dunning's biggest point would be, please give us an extension, because otherwise these people will not be able to pursue their claims. Would he have made that point? Of course he would have done. Very experienced advocate, of course he would have done, and he acknowledges that he did. Is it really conceivable that she didn't understand that? It is, in our respectful submission, absurd, and it's clear that it's not true. What does she say? She recognises what he says, maybe shortly, but still it's recognised. So paragraph 19. She shortly summarises what Mr. Dunning submitted. As against, she sets out fully what he said about our case. As against that, says no prejudice, he says, to us, but it's submitted by the claimants that if they're not allowed to plead the date of damage in relation to the additional 900 or so names in the schedule, those claimants will be particularly prejudiced because they'll not be able to advance their claims. And we looked, and maybe look again at what Mr. Dunning actually said to her. And I do, with respect, suggest that it's pretty rich to complain that she didn't understand something which she chose not to say to her. If we look at the transcript, please, it's tab 33 if I remember correctly. Two particular passages, I mean, my lords have seen and read in tab 33, starting internal page, transcript page 40 and on. He says clearly at page 40, page 296 of the supplemental bundle, if they are not permitted, lines 10 to 11, if they're not permitted to add to the dates, many individuals and communities will not be able to pursue their claims. He said that very clearly. Of course she understood it. He didn't choose to say only 4 of them will. Well, that was his decision. But she knew what claims there were, and that's all that he put to her. And we come back to it again. Because, and this is the passage that I invited my lords to look at earlier, when he actually told her what the consequences would be. He said, and this is page 32 of the transcript, page 294, the bottom line, this was leading counsel's submission. The consequences for there to be an extension as opposed to no extension are as follows. On the defendant's side, if there is an extension, the consequence will be minimal. That's the alleged no prejudice. On the other hand, the consequences for the claimants will be, if no extension is granted, that any of those 900 or so communities and individuals who are currently able to put a date forward, hopefully there will be some more, because their case has not been pleaded, they will be shut out. So he said clearly that they would be shut out. He chose to put it in terms of the 900 because they're the only ones he knew about. And they're the only ones we knew actually, and the judge knew actually might be affected by it, because he didn't tell her anything else. He hoped there might be some others, and she didn't say 900, she said 900 or so, which could be covering that possibility of more, but it doesn't change the...
There is a confusion about the 900, isn't there? Because, well, firstly, I find it more straightforward to talk about communities than people.
Well, that may be.
Let's say 6 communities, which is what he said earlier they were concerned.
I don't know whether 906 communities or more. I really don't know that.
No, but the point is that these are the ones where they will be able to provide the information today, July the 2nd. He hopes there will be more.
Yes.
Yes, I see. The point I was really about to put to you was, well, all of those, the 900 plus all the rest, won't be able to pursue their claims. But the real point, I suppose, for the judge is, I'm looking at those who will be able to do so given more time. The rest are irrelevant because they're hopeless anyway.
Yes.
Yes, I see. Yeah.
Yes.
So the real question is, it might be 900, it might be a lot more. But I've got there, yes, thank you.
Yes. And senior QC will bow to Mr. Dunning's experience and length, in a good sense, length of service. This is what he submitted to the judge. He submitted, this is what the consequence would be. now to complain that she didn't know there were more. But in any event, it follows. I want to just make one submission in relation to the date of damage pleading that was served, because it takes me on to another point. My lords were taken to it, but not to one paragraph, which may be helpful just to underline. The date of damage pleading is in the
The date of damage pleading.
Yes, I'm sorry, I keep
It's our bundle 4, tab 16.
5 in my case.
Oh, right. Well, I might have been spared some of the schedules, for which I'm very grateful. But anyway, it's tab 16.
Yes, I'm looking at the wrong bundle as usual.
Starting at 1048.
Yes, I've got it. I, of course, have it tabbed, and then took the wrong volume of this. So, and there isn't more, as my lords say, but can I just note this, that paragraph 2, which my lords weren't taken to, notes that the date of damage schedule is served only in respect of those people. Now, my lords may have picked that up already. It's not just that these are the only ones who produced evidence, but the pleading itself expressly is said only to be for them. And we don't know why that's so, but that's what they've chosen to serve. And it's interesting because my lords may have picked up that the other named claimant is Mr. Tujaw. It's not only does he not give evidence directly. I know there's then a Civil Evidence Act point about they want to serve previous statements. And he's not even a person in respect of whom this document is being served. So the two of the two alleged lead claimants, one of them isn't even serving a schedule at all, pleading at all. And my lords have picked up, of course, it's very limited because it's limited then to effectively the 5 communities identified in paragraph 2.3 and the 4 individuals, including one of them being Mr. Jalla in paragraphs 2.1 and 2.2. And then when one looks to see what is actually pleaded, of course, it only pleads the arrival in the places that those particular individuals represent. So, did they? And this is again would go to any re-exercise of discretion, but looking at it generally, I want to make sort of 2 points. One is we know that no evidence has been served actually in respect of the claims that these people suffered at this particular date, over and above the witness statements that have been served. We know that Mr. Dunning is not going to serve any evidence in relation to the date of damage, even though it's clear that that is what Mr. Justice Stuart Smith envisaged. Now, he gets around that by saying, well, so be it. I'm not obliged to serve it. And if I turn up at trial and haven't served it, I'll have to take the consequence of what the judge says. But if my lords were considering the question, should they grant a further indulgence to the claimants, I would respectfully submit it's a powerful factor against that actually to do what they're now suggesting is not going to do what the judge hoped would be done, and isn't going to advance the case at all, because as my Lord Justice Underhill put repeatedly to my learned friend, without evidence, they can't prove a claim, so it's pointless. My Lord didn't say so it's pointless, I'm adding that. So can we look at what's actually been done? can we look at whether it really is the case that they've strained every sinew? It's odd. It's very odd. My lords, I think, have already picked up that from the witness statement, Mr. Roach doesn't demonstrate that he visited the community from which these witness statements have actually been made. In fact, and I can make the point, but we can go to the witness statement and show it, if one looks at what he says he did do, the communities he said he did actually manage to visit, there's no witness statements for any of those, no pleading for any of those. So what actually was going on? We know from what they've said elsewhere that actually they have the opportunity to obtain materials in another way. Could I take my lords to... I apologise for a moment while I turn up the right part of my notes. I don't know whether my lords have seen references, for example, to an organisation called OSPIV.
Yes.
Mr. Jalla refers to. So what we know, and I'll give my lords the references, but perhaps I just identify what's said and my lords can decide whether to turn it up or not. One is, OSPIV says it's got a permanent office in the city of Warri. That's in Mr. Jalla's affidavit dated the 11th of June, which is in his supplemental bundle at tab 42, page 380. It says there is a permanent secretary receiving, transferring and handling all documents pertaining to this court case and liaising with the general cohort of claimants. Perhaps we just should look at that. That's in the supplemental bundle tab 44, page 397. Tab 44. So if my lords see that Mr. Aloysius Okarieka, he says he's the secretary of the Coalition of Bongo Oil Spill Communities, and his duties include receiving, transferring and handling all documents pertaining to this court case and liaising with the general cohort of claimants, including the lead claimants. And he gives some more explanations about that. He talks about, in paragraph 7, about the pictures that are held in the office. This arose in the context of a complaint we made about evidence which had been produced purporting to show pollution to land of Mr. Jalla and Mr. Chujor at a particular date. My lords may recall seeing this, where the learned judge said, hang on, this evidence is completely suspect because the people shown in the photographs actually, though they're said to be at different dates, said to be employed by different people, are actually wearing exactly the same clothes. And he required evidence to be provided to explain that. And the claimants admitted, oh, we made a mistake. Anyway, this is Mr. Okireke. But anyway, he says this is his job, including liaising with the cohorts. And the office is said to be in Warri. Well, Mr. Roche even says he went to Warri. That's paragraph 39 of his statement. But he doesn't say anything about finding any documents there. We know that meetings took place. Tab 41 of this bundle, the witness statement of Mr. McCloskey of Debevoise. He exhibits, at page 374, starts, if one looks at 374, there's a meeting takes place. My lords can see from the caption under the photograph that Mr. Okarika and Mr. Jalla, whose names we just come across, they're part of the meeting that takes place of OSPIV. And it's noted at the second page of whatever it is, a press release, affected communities attended the meeting. December 2020. Mr. Roche says nothing about this. Ms. MacLeod says nothing about this. They say nothing about whether or not this was a means in which to obtain more information about when particular claimants said that they suffered damages. There was a further meeting with community leaders, all 479 community leaders, on the 9th of February 2021. That's tab 45, page 406. This is Miss MacLeod's, one of Miss MacLeod's witness statements. And she says in paragraph 15 that a meeting of the 479 community leaders called to take place on the 9th of February 2021. Statements were executed, arrangements made to send the statements to us.
So which paragraph?
Paragraph 15, my lord. This is a statement sworn, or signed at least, on the 11th of February 2021, but by July, months later, the documents she refers to have apparently not been transmitted, certainly not to us. Don't know whether they have or haven't been, but certainly there's no explanation as to why this wasn't an opportunity and didn't result in discovering more information about when date of damage took place. And I'd like to invite my lords to look at the claim form because there's an interesting schedule. The claim form is at the core bundle tab 15. And I want to invite my lords to turn to page 323.
Sorry, tab.
It's tab 15, my lord. It's a big document because it's all the schedules.
Tab 15, page 323.
So that's the second bundle of the core bundle.
That's the second bundle of the core, yes, indeed. 323 is sort of the start of the schedule, Schedule 1. And I just wanted to refer to the fact this is the schedule of all the claimants.
In Jalla 2.
In Jalla 2, but they're the same claimants as we know. Yes, it is, that's right.
They're not precisely the same.
Not, my lord, of course,
Because I
right.
was told on the last
Yes, my lord's
occasion,
quite right.
I haven't been able to find any sort of Venn diagram. But, at all events, there is a large, I'm told there's a large overlap. We are told.
And that's the whole reason, of course, why Jalla 2 has been started. To try and get...
So we're looking at this. These are the list of claimants
Yes.
in Jalla 2.
And all I'm wanting my lords to look at is the fourth column, which is headed with the words phone number. And one can turn over the pages. That pretty much all of them have got a phone number. And indeed, Miss MacLeod says, paragraph 11 of her witness statement.
But it's not entirely. I see. Yes, there are. I've obviously done this exercise before now. You go to 349, and then the phone numbers stop. And there aren't any phone numbers. It's maybe a characteristic of that particular community or those communities, and don't start again until much later.
Look, that is so, but there are thousands and thousands of phone numbers.
Well, even that's not quite straightforward. So when you get to 385 following, you've got page and pages of the same phone number.
Even so, my lord, the point I'm making simply is it's never been explained why.
No, all this needs to be explained. Yeah.
So why can't they get the information using the phone numbers?
You only need one responsible claimant per community.
You may only need one responsible.
Yeah, I see you don't accept that, but
Well,
realistically, if one person says oil washed up at such and such a community on such and such a date,
I'm going to
give or take, there isn't much likelihood that there'll be a different date for any of the other claimants in that.
I'm afraid to say, though my learned friend doesn't like, we're deeply sceptical of this claim and we're deeply sceptical of material that we get. There's lots of examples of stuff that's come out which is really very, very troublesome.
Well,
so I'm not prepared to accept, but it doesn't matter. For present purposes, my lord, all I'm saying is, even on their case, why is this court not being told? Why wasn't Mrs. Justice O'Farrell told? Well, we tried to use the phone numbers, but we couldn't get answers. Miss MacLeod says that's the usual way to get information. She didn't need Mr. Roach, the ex-Marine, and his gunboat in order to get the dates of damage, which is all that Mr. Dunning now says he wants to produce. And indeed, he hasn't, and I'm not inviting him to give any evidence. Perhaps I won't make that statement. We still don't know why it is that allegedly, back in July, they could only get information from 4 people in 5 communities, but now thousands and thousands and thousands. I would invite
I think
this
you're
court.
better off sticking with the evidence as it is.
Yes, my lord, I absolutely am. And that evidence does not include any explanation as to how it comes about. But this is all that they were produced by July. They should be throwing themselves on the mercy of the court, as my Lord Justice Coulson said. They should be saying what they've done, why they haven't been able to. They never did that. And that is a powerful reason why they shouldn't have this further indulgence. My lord, they'd already had, this is my next point I want to make, they'd already had 3 extensions of time. And they ended up having 16 months to produce this information, which my learned friend says now will be satisfied by simply a schedule which adds the date of damage to a number or many of the claimants. 16 months to provide that. I'm going to make one point which is perhaps a footnote, but just because my own friend said it, he said, "Oh, well, please be kind to us." I didn't quite say those words, but that was the implication, because Rosenblatt have only been on the record since August 2021. That may technically be right, but they were effectively the solicitors acting since 2018. And the reference to that is Mr. McCloskey's statement, and about my Lord Stand Up, I'll give the reference anyway. Supplemental bundle, tab 41, para 52. They described themselves at the time as being agents for the person who was on the record, Mr. Ekorotomwen. They appeared to be running the show. Their people turned up at hearings, they corresponded, whatever. So we said they were effectively assisted. So it's not an answer, even if it were an answer, to say one's lawyers weren't doing a very good job. We know from what is said in the judgment that Mr. Jalla, described by Mr. Justice Stuart Smith, maybe rather generously, as an important and responsible person, but has been dealing with this from the very start. He's the one who started OSPIV. Got no explanation as to why he wasn't able to assist in getting the answers to these, what are now said to be quite straightforward questions. And they've got Nigerian law firms involved and local agents, all of that. So if it comes to considering discretion or considering how the judge dealt with it, it's simply not right to treat them as having done all they could. Why they failed to do more than they've done, maybe because they adopted the iterative approach that they were told not to adopt, let's do the minimum we can, they get away with it. I don't know. The fact is what your lordships are faced with is that's all that there is. And of course, the third point, if I got to three, is they were given ample warning not to do that. The iterative approach comment is one of them. But they were
What's meant by iterative approach in this context?
The iterative approach was in the judgment that we looked
I know, I understood almost every word of that judgment, but not that particular.
Well, what I mean is constantly coming back with a variation on the claim or a bit more, putting the case in a different way.
Yes, I see.
That's at least what I mean.
That makes sense.
Yeah. We also, whether this is what Mr. Justice Stewart Smith meant, I'm not sure, but it's also bringing up evidence at the last moment, which has been a hallmark of the way this case has proceeded, and anyone who's dealt with it will know that. But there we are. But the two particular warnings, the three warnings really. March 2020, in that remark from Mr. Justice Stewart Smith. November 2020 by Mrs. Justice O'Farrell in her judgment on directions. And thirdly, in the correspondence with my firm in relation to the extension we did agree. May I say a word about that? Your Lordship's seen it referred to.
This is the correspondence in May.
Yes.
Giving rise to the consent order in June.
Yes, and it's summarised by the learned judge, so I'm not sure I need to take my lords to it, though it's in the bundle if one needs to. Essentially, we were very clear, and she recognised we were very clear in saying we won't agree to any more extension. This is your last chance. They took that extension at a time, frankly, they must have known it wasn't going to meet their requirements.
Well, I wondered about that. Is this right? There is no evidence in these bundles that suggests that they could have met the order by the 2nd of July.
No evidence of that. There's no evidence of that. Because it's within a very short time that they're saying we need more.
Because there's certainly no evidence that something dramatic happened in June, which meant that they were going to be there, and then because of this, that, or the other problem, they couldn't be.
Now, they took the point when it came to it before Mr. Justice O'Farrell, well, we never said we wouldn't make a further application, and she said that's right.
In one sense, that's worse, because that is agreeing to an order knowing you're not going to be able to comply with it.
Yes, yes, ma'am. We obviously feel, if they hadn't agreed, it would have come as at time summons before the court, and the court could have decided, and an unless order could have been made, and we wouldn't be here now. But they chose to deal with it in the way that they did. But I'm saying really that's the third warning. And yes, it's true we didn't actually say we did say you'll have no more extension in effect. We didn't get them to explicitly. We said you must agree. This is on the basis that this is what's going to happen. They didn't actually write back saying yes, we agree. Anyway, that's what the learned judge decided. That's not the correspondence didn't amount to that. But the fact remains, it was us saying no more time, and yet they went for more time. And it's an appropriate moment to make this observation, given what my learned friend said, we agreed to that date. Yes, we did agree to that date. That does not mean that it didn't already cause prejudice. We thought we were being reasonable in trying to accommodate them. Don't bother the court. We're already up against it. They actually, I think, wanted 2 months, and we said, we can't give you 2 months, we'll give you a month or a month and a half. And they took it, and then came back for more. And now they've come to this court as well. So I was really just saying, so far as the, just finish my point on, have they strained all sinews? We don't understand also. They've obviously known what it is they've taken on. In March 2020, they represented to the court that 85% of their claims were not time-barred. We can hand that, that's in their skeleton for the consequentials hearing, paragraph 35. It's not actually in the bundle, but if my lords would like to see it, we can provide it. The point is, they were telling the court in March 2020 that 85% of their claims were not time-barred. What was that based on? Did they know that already because they'd actually ascertained the dates of damage for the individuals? If so, it might be a justified statement, but it also means, why couldn't they provide more in July? If it's not a justified statement, well, why on earth was it being made? They'd also told us, before coming on the record, they were undertaking an extensive due diligence exercise. Again, we can provide that if my lords would like to see it. It's not in the bundle. But at the end of the day, what the two witness statements they rely upon actually show is logistical difficulties. We know there were logistical difficulties. They'd been warned there were logistical difficulties. Mrs. Justice O'Farrell said, really, you're going to go to Nigeria? You know you're not, it's advised against. But they knew all of that. The witness statements really don't get to the level that they ought to if they're asking this court now to exercise great indulgence and allow them to have time that they had. And my lords will have seen that, as the learned judge found, the difficulties they now complain of had already been factored in. The pandemic, Mr. Justice Stuart Smith says he would have given them 6 months, but he gave them more because of the pandemic.
Yes, so I think that was in March 2020.
My lord is right.
When it wasn't anticipated there would be a second and a third and a fourth wave.
That may well be right.
So that may not be the strongest point, but nevertheless, it was being quite generous.
Yes, and then come November, when they come back before the judge, by which most just so far when it's known that this is actually not a short-term thing which is going to be over by the summer, she takes account of that and takes account of the difficulties in the Niger Delta too.
Yeah.
And that more than doubled the time that had originally been given.
Yes, yes, and that's why we end up with overall 16 months, and now even more. So, my lord, I mean, fundamentally, we have a case of an experienced judge who plainly considered all of the factors because they were put before her in a substantial hearing, a one-day hearing. I mean, one day, a whole court day to consider whether a time limit should be extended. I mean, very, very unusual. It illustrates the extent to which she was prepared to listen and did listen and consider all of the points that Mr. Dunning and his team wanted to put before her. And reached a decision with which we respectfully submit this court ought not to interfere. My lords understand that, in a sense, is our primary point. No error of law. We didn't try to persuade her she didn't have discretion to do it, for example, because of the agreement we say was made in correspondence. We say it was made, but we didn't say you haven't got discretion to extend it. We accepted fully that she had the discretion to extend it, and that's what she did. So, my lords, I'm going to, I think, your lordships know from our written submissions what we say. I just want to deal with one other point, and any other point that my lords think I should deal with that I haven't. There's a strong appeal to access to justice from our learned friends. And we're all very much in favour of access to justice, but there are limits to it. My lords, they've had 10 hearings. They've had 8 judgments. They've been to this court now 3 times. They've got 1 application to the Supreme Court already being considered and threatened a further one. This court, these courts, have granted every indulgence to these claimants. And it's right that the learned judge was entitled to make the decision that she did. It will plainly result in vacating the 4-week hearing that's been set down. That is prejudice to us, but to others too. And the learned judge was right, and as head of the TCC, entitled to consider what the implications for others were. And your lordships have seen what she said about other cases having been pushed off because the date was fulfilled. My lords, quite exercised by this, but that's not really the point. If there are further points that your lordships think I should deal, please, I would be very happy to do that. Otherwise, I think those are our submissions, and I'm grateful to the court for that.
Lord Coulson, can I just ask you the same point I put to Mr. Dunning? If the court was re-exercising its discretion, I would have thought that, at least by analogy, the Denton and White analysis is potentially of some relevance, and
yes.
Heard the debate that I had with Mr. Dunning about that. Do you have anything to say about that?
I wanted to turn up our skeleton before Mrs. Justice O'Farrell, because we recognise the significance of Denton and White. I think we referred to it in our skeleton, because it did seem to us, obviously we were saying that they were asking for relief from sanctions, but whether or not they were, respectfully agree with my lord, or my lord's suggestion. Of course, the factors referred to in Denton and White must be things for the court to consider. What the extent of the delay, what the culpability is, what the consequences are, and those three things which were identified by the court.
I mean, in its most basic form, it is an approach to seeing the overriding objective in action.
Yes.
In a case where one party needs the help of the court, putting it no higher than that. Hence I raised it with Mr. Dunning, because it did seem to me, at least potentially, that it was an approach. Anyway, it was something that you raised before Mrs. Justice O'Farrell, and
yes.
You say that even if it isn't a case of sanctions, and therefore relief from sanctions, it's not an irrelevant approach.
Sorry, my lord, yes. Didn't mean to turn my back, so I was waiting for a note which took time to come. My lord, yes, that's right. May I just give my lord the reference?
Yeah.
Our skeleton, which is in, is that core bundle, that tab 8?
Yeah.
Tab 11, sorry, tab 11, paragraph 43 onwards.
We can look at that. Paragraph 43 onwards.
43 onwards, yes.
Thank you very much.
Thank you very much, Lord Goldsmith. Yes, Mr. Dunning.
Well, just, if I may, just to respond on a few points. I'm not going to go over everything again, obviously. My Lord, if I could start with the evidence of Miss Atemi, which Lord Goldsmith took you to. This was obviously evidence to which I referred, and we relied. But Mr. Goldsmith, or Lord Goldsmith, also seeks to rely on it. And he read you paragraph 9, which is in the supplemental bundle tab 15, page 84. And it is her evidence that the Bonga Royal didn't affect Nigeria, and I quote, it is highly implausible, the words that she uses, that it was Bonga Royal. And that's in paragraph 9. And then she goes on to say, it is far more plausible that it was one of these other sources, and you've seen from the paragraphs that he took you to that she's gone into great detail as to, and including giving dates of other alleged leaks of oil, as to what she says is highly more plausible was the oil which affected the claimant's land, if it was affected. And this is the evidence that I was referring to when I said, putting it very bluntly, the dates don't matter to the defendants, because it's their case that it's highly implausible that it wasn't Bongarol at all. Let's take a comparison, if I may, with, say, a classic limitation case where there are cracks in a building. Lord Goldsmith, in that position, his case is there was no crack. Or alternatively, if there was a crack, it was caused by one of the other contractors and not by us. It's not that the crack occurred at a different time. And so that's why why we rely on this evidence.
But isn't part of what he was saying was, if we know that it's alleged that oil came ashore at Community A on the 1st of January 2015,
Yeah.
we can see whether there is a reported spillage from something else on the 31st of December 2015,
Yes.
a couple of miles away.
I accept that. And that, because that's the other point that I was going to come to. First of all, Miss Atemi has already done that in her witness statement. She's already covered comprehensively the two states and reported all the other spills that she thinks are contenders. But there's no indication that it would take her more than a week or two to cover any additional ones. This was evidence that was prepared and served in great detail in the context of the interlocutories. It didn't take her long to prepare. This is her job. This is what she does. She monitors all these spills and prepares this sort of evidence. And there's no indication that if she got this list of dates tomorrow, she wouldn't be able by the end of November to have seen whether she wanted to refer to any additional spills other than the many, many spills that she's already referred to in her witness statement, which has already been served. So that's what I say about that. It cuts against Lord Goldsmith's position, and we rely upon it. So far as ground one is concerned, Lord Goldsmith sought to put into context and explain the 900. I would only say this, that I showed you this morning that when I referred, first of all, it was the passage in the transcript that Lord Justice Underhill raised with me, I said there were 900 at present, but we're still working on it. And so clearly the intention was that by the 20th of August there would be a greater number. But what Lord Goldsmith didn't, unless I missed it, what he didn't focus on was those words in paragraph 42, where the learned judge talks about perfecting their case. And so we have the statement there that she explained the application as being one to perfect the case, whereas it wasn't in reality, in substance, one of perfecting the case. It was being allowed to pursue any case on behalf of all of the claimants other than the 9 who had provided dates on the 2nd of July. And as Lord Justice Coulson said to me this morning, you rely, he put it to me, first of all on the absence of any reference to the draconian effect in paragraphs 37 to 45. And that's not that it wasn't argued before the learned judge, it certainly was argued before the learned judge, but what appears to have happened in her extempore judgment is that's not something that she has evaluated and weighed in the balance in paragraphs 37 to 45, and instead she has referred to it as not having the opportunity to perfect their case. So that's that part of my argument from this morning I respectfully submit, is still intact, notwithstanding Lord Goldsmith's comments. Now, then Lord Goldsmith made a submission, I think, based on some of the observations that Lord Justice Underhill had made, to the effect, if I can wrote it down, that without factual statements, it's pointless to plead dates. Now, we don't accept that, and the reason we don't accept that is that trials develop in unexpected ways. What we have here is we have served evidence of a number of factual witnesses, and we have served further factual witness statements under Civil Evidence Act notices. We have served expert evidence on the migration of the oil and how it can be below the surface and not visible, and then can come up and can migrate. And we will be submitting, those conducting the trial will be submitting, that inferences can be drawn from that evidence. And then, of course, at the trial, one has cross-examination. One assumes that Shell will be calling witnesses, such as Miss Atemi, who can be cross-examined. And witnesses sometimes give things away in cross-examination, especially someone who knows a lot about these matters, such as Miss Atemi or some of the other witnesses whose job it is for Shell to monitor environmental pollution and who are likely to be called as witnesses. And we will be cross-examining them to say that their entire case that they're putting forward is wrong. I mean, we say there's strong evidence that the oil did come to the Atlantic shoreline, notwithstanding their numerous witness statements to say it didn't, and it was all cleared up. We say the whole idea of a mystery spill is an unfortunate one, given that they had themselves procured the Fugro report, which says that it was Wonga oil that came to the coastline. We have a tenable theory of the migration of the oil, supported by very reputable experts, EPE. Given the vast scale of this spill, 40,000 barrels, there's obviously a potential for vast environmental pollution. Now, weighing up that evidence is not for the court to do today. It is for the trial judge. And I just want to make this point, because it may be that one lose sight of it. On any view, there is going to be a trial of claims of those for whom the dates were served. And that will take place in February and March next year. And so the trial judge is going to be evaluating that evidence for the purpose of the claims of the 4 individuals and the 5 communities. And the question for this court is, should there be an extension to enable the dates of damage of other claimants to be put forward, so that on the basis of the evidence that already been served, the judge can evaluate whether or not he can draw inferences that they were damaged by oil. That is the question, whether the trial should be limited to those 4 individuals and 4 communities, or extended by virtue of a date of damage schedule dates for the other claimants. And I would respectfully submit that the defendants are well prepared for this trial. And Lord Goldsmith is clearly well prepared, as he demonstrated in his submissions today. And I do ask the court to take a pragmatic view, that the notion that they will be materially prejudiced with all their knowledge and expertise and investigations into these matters and not be able to deal with extra dates if they were pleaded in a schedule in the next 24 hours or within 24 hours of the court's decision is not a tenable one. So that's what I say in relation to prejudice and the risk of the trial date being jeopardised. Could I just a couple of other points, very briefly, my Lord. There is evidence that the claimants believed, I think this was Lord Justice Coulson's question, that they could comply with the date extended by the consensual extension. I think Lord Goldsmith either said or implied that there wasn't evidence. And that evidence is in the supplemental bundle, tab 25, SB page 143.
Supplemental bundle, tab 25.
SB
Statement of Miss McLeod, yes,
paragraph 7.
I mean, that could not be more general.
Well, my lord,
That could not be more general. When you're throwing yourself on the mercy of the court,
okay.
because on your case, all of these claims would otherwise not be capable of being pursued, one tends to explain actually what happened.
Well, my lord, I said it could be more specific, but the point I was
It's
making
not
is-
even clear. It's not just not unspecific. It was their belief that significant ground could be covered within that time to make good the aspects of the order that had proved most challenging. I mean, that's very unclear what that means, but the natural reading is we didn't actually think we'd be able to deliver it by that month to which we'd agreed, but we get a lot closer.
Well, my lord, I thought it was right. You should see that evidence, because it isn't right to say there's no evidence on the point at all. I can see that you've got criticisms of the evidence, but it isn't right to say that she didn't give any
And it's
explanation
it
of
says
that,
the
really.
claimant's belief.
Well, yes, because all of
The
these
solicitors are the people who agreed the extension. I probably wasn't clear in my question. Where's the evidence from the solicitors that the solicitors believed that the order that they had agreed could be met?
Well, that I'm not sure there is any evidence of the solicitors.
It's the solicitor's witness statement. Why doesn't she say what she thought?
Well, I don't know the answer to that, but there is some evidence on the point, and it's that's the evidence that there is. And finally, on phone numbers, there is some evidence in relation to that. First of all, as Lord Justice Underhill already picked up, it is not right to say there's a telephone number given for every claimant in the schedules, and from pages 349 to 385 in Core Bundle 2, there are, for example, I think 1,500 consecutive blank entries. And also, I think as Lord Justice Underhill also picked up, there is the same phone number, which ends 588, or alternatively 500, which is given for 1,000 consecutive
But-
individuals. And
I did indeed pick those points up, but Lord Goldsmith's response, which seems to me to have something, is that all this needs to be explained.
yeah, and there is in fact some witness. I just want to show you.
Oh, I see.
There is some witness evidence on telephone numbers as well. Again,
Where is that?
it's not entirely satisfactory, but I just wanted to show it to you, as the point was made that there was no evidence about that, and that is in the supplemental bundle, tab 47.
27.
47, my lord.
And if it's the supplementary bundle, mine stops at 46. Oh, I see. This is some of the extra stuff that came later.
Yeah, this is Mr. Jalla.
It's Mr. Jalla's witness statement,
Yes.
which for some reason we spotted it got left out. But it's obviously it's dated the 2nd of July, and this is his witness statement for which was served on the 2nd of July. But on the last paragraph, he talks about the difficulties of getting information, and that's in paragraph 28.
Give me a minute.
On page 425.
Yes, I haven't even got to that stage yet. I'm just trying to put it into the bundle.
Not specifically about telephones.
No, what he says is, as I've outlined above, many individual members of the communities are illiterate, do not speak English, or do not have access to the type of communication devices which would allow for the discourse necessary to provide useful witness
Yes,
evidence.
but you agreed, I mean, Lord Goldsmith is rather cautious about agreeing, but you agreed that what you would expect to be able to be possible, and this is some extent confirmed by the reference we've seen to representatives from the 400 communities, is that there would in each community be at least one person who was contactable and who could be the spokesman for that community and could say, even if they had to be translated into English, I can remember that the oil first washed up on such and such a date.
Well, in theory, but in practice, it hasn't proved to be.
Well, there's no evidence that that's so.
No, I know, but I'm just saying. This is the point about. There seems to be some sort of assertion that the claimants and their solicitors have been sitting back and not trying their best, and they have been trying their best.
It's the boots on the other foot. The submission was that there was no evidence as to what they've been doing, apart from generalities and irrelevancies about the boat patrol.
Anyway, my lord, I have shown you the evidence that,
Yes.
That was
No,
missing
thank
there.
you.
And finally, if I may, just in relation to, again, coming back on Lord Justice Coulson's question about whether this is analogous to relief from sanctions, I made one point in relation to that before the short adjournment, namely that this is not, there was no sanction attached to this. Of course, there is another reason why, in principle, the relief from sanctions line of authorities doesn't apply, and that is because, as far as I'm aware, it's always been generally understood that provided one applies before the time has expired, or at the same time as the time expires, it's not a relief from sanctions situation. It's a relief from sanctions situation where you are applying after the time has expired and there is a sanction attached. And so for both of those reasons, we say that that line of authority is not applicable because this was an application.
So you don't accept that it's a way of seeing the proper application in a case like this of the overriding objective?
I don't accept that, my lord. I've accepted that it's a case management decision. There's a section in Zuckerman which I think we will, if you want to look at it, we might find helpful on appeals on case management decisions, and a specific section I can give you the reference to that. But I don't accept that it's a relief from sanctions case. It was an application for an extension of time for a specific pleading effect to go in to supplement what had already been put in.
Yeah.
And it was made in
You have to
time.
be slightly careful playing it down in that way, because then we might forget that the draconian consequences are 28,000 people can't pursue their claim.
Well, that's a consequence, but it isn't actually a sanction.
No, I understand.
And it was made in time, and that is the watershed point has always, in practice, as my understanding, been a significant one as to which line of authorities you apply. So, unless there are any further, no, and those are my submissions. Unless there's any points that are
No, thank you. I think what we will do is rise briefly to see whether there's anything useful we can say before we rise. So stay there.
All right. It's a short adjournment, so if you can be swift, thank you.
so that thing is still on.
I didn't hear it. You know, maybe people join at the same level.
Council, the Lords are ready. If you're ready. Yep. All rise.
No, I don't think there's anything substantive we want to say now. We are quite confident we will be able to give you a decision, probably with reasons, but certainly, if necessary, without reasons, in good time ahead of the forthcoming hearing. I had forgotten, I know there's one, is it in November?
This week.
This week?
Next week, Friday. There's a case management conference which.
I'm sorry, I'd misremembered that. So it's really pretty soon.
Yes.
What day? What? I don't want a date for that.
Friday the what?
Friday. Very well. Well, you will have a decision in good time before that. The chances that it will be without reasons at that stage are rather higher. But we are confident we'll be able to give you a decision sometime next week before Friday the 8th. Or, yeah.
All I can say is we wait with anticipation.
Yes, I mean there is no more you need to know. Obviously, the sooner the better. I can see
of
if it was on Thursday, it'd be very inconvenient for everyone. But
yes,
we just need time to think and make sure we know what we want to say.
Yes.
Yep.
All right.